now. It's hard to believe. Many things have happened. We're going to cover a number of those, of how you can mitigate your risk and stay out of legal water. We're going to go ahead and go next slide here. In terms of, before we begin and get started on the substance, let me give a small legal disclaimer. This presentation has been prepared by Seyfarth on behalf of easyBackgrounds, and it is only information purposes only. It's not legal advice. I am a lawyer. However, you're listening to this does not create any sort of attorney-client privilege relationship. You can read the rest of the disclaimer here. But please understand, this is for informational purposes only. We're going to try and give some best practices, tips, and some takeaways. And at the end of our time together, we will try and answer the questions that are asked. So if you do have questions, all of you are in listen mode only, so please feel free to use the right-hand box at the side of your screen for questions and ask those while we're going through it at any time, and we will try and address those at the end. So what are we going to talk about today? A little bit of a recap from the end of the year that is sort of blown over to now 2016, and what are we seeing, what has been happening, specifically areas, the two hottest topic areas for employers in terms of litigation. We're going to talk specifically about the FTC and what the FTC has said about theories with workplace investigations, and also what they've been doing. They and the CFPB, the Consumer Financial Protection Bureau, which is the other regulator in this space, what they have been doing to target employers and background screening companies to ensure that they're compliant with the Fair Credit Reporting Act. We're going to talk about the very recent Robbins versus Spokio ruling that came down on May 16th and what it means and what it doesn't mean, and talking about what we're going to see going forward. With that, I'm going to talk a little bit about the litigations that we started seeing in 2015 and now have spilled over to 2016 as well. And what we're really seeing here is, and we saw this kind of starting back 4 years ago, really picked up last year and continuing very much so this year, that plaintiffs' counsels, new plaintiffs' counselors are coming to the table. Plaintiffs' counsels who were class litigators in other types of areas of the law, like wage and hour, for example, or other different facets, are coming to the table and trying to make businesses out of suing employers. We now have about 10 or so firms that we are aware of do this day in and day out, and this is all that they do, is specifically have background checks as their area of expertise and what they're looking for to employers and background screening companies. Because of that, we're seeing much more of a consolidated information sharing effort. So what does that mean? It means that plaintiffs' counsels are holding forums, they are having conferences, they're talking to one another. Gone are the days where they're fighting and arguing about who's going to bring the case, but instead they're all coming together, and oftentimes we see on a complaint, not one plaintiff firm or one plaintiff counsel, but 3 or 4 or 5 plaintiffs counsel on a class action, for example. We're also seeing copycat lawsuits. So as soon as one law firm files a lawsuit against a company, oftentimes you see multiple other claims that are filed in different jurisdictions, for example, alleging similar or a little different theories. And it's very interesting because it looks like the floodgates open when you get sued, which is terrible. We are seeing multi-jurisdiction lawsuits in forum shopping. What do I mean by this? And when we'll talk about the Spokio case in a few minutes, you'll understand that this trend is absolutely going to continue. There is just no question. What we're seeing is, because of the different laws in different jurisdictions, meaning, for example, the way they've interpreted the Fair Credit Reporting Act or the way they've interpreted the standard requirements, now that we've got the Spokio case and what the Supreme Court has said about certain issues with regard to when a person can bring a lawsuit, when a person has, quote-unquote, standing to actually have the right to bring a lawsuit. We're seeing a lot of this forum shopping and cherry picking which jurisdiction someone will want to file in. Obviously, the Robbins versus Spoke case was filed in California, and then the Circuit Court of Appeals, that's generally known to be a relatively liberal circuit. And so a lot of cases are being filed there. A lot of cases that are being filed on the coast in Virginia, in Philadelphia, some in Minneapolis. And so we're seeing the crux of these types of cases. We're also seeing a huge increase in 2016 showed us this even more of advertising. Plaintiffs' counsels going and advertising on either Craigslist or with websites or using Facebook. We've even seen targeted letters being written to companies and employees saying you may get money if you had a background check, for example. So lots of things that we've seen before on that issue as well. And then we've seen a huge amount of increased litigation on disclosure forms, and we'll talk about why that may stay or why that may go away as part of this as well. And obviously, you know, what we're talking about today is a little bit of what's been happening. We are going to talk a little bit about in the box and the EEC criminal history guidance. It's been 4 years since that guidance, so we can chat a little bit about that as well. What's the first big issue in terms of you, an employer, navigating your way through the world of background checks, and where are we seeing litigation, and what do you need to do? Well, first and foremost, there's 4 responsibilities if you are an employee under the Fair Credit Reporting Act. First, you must provide first you must have a permissible purpose. That means you must have a reason why you're getting a background check. Generally speaking, if you're an employer, the permissible purpose is an employment purpose. And it's very easy to understand that the FTC has opined that volunteers and independent contractors will still fit into that employment purpose prong. That would ring true, at least arguably, for members of the gig economy. But understand that it's a little bit of an open question because there's been 2 cases that held that independent contractors do not fall under the guise of the Fair Credit Reporting Act. But it's certainly an open question, and the conservative advice so that you don't get sued is to have the FCRA apply to all of those different entities. The second requirement, as if you have a permissible purpose of an employment purpose, is that you must have a disclosure and an authorization. That's what we're going to spend the next few minutes talking about, and the specific requirement and where those are being challenged. The third requirement is that you must take, if you are going to take any action in whole or part based on report, you must follow the 2-step adverse action process. Again, that's the second area we're seeing the most increased litigation, and we're going to spend a few moments on that today, talking in detail about some of the pros and cons and where employers actually get burdened on those types of restrictions and responsibilities. And then finally, the last responsibility you have as an employer is that you must certify to your background check company that you have followed all these things, that you have a permissible purpose, that you will get the disclosure and authorization, or frankly, that you have the disclosure and authorization. It must be past tense, that you will follow the adverse action requirements, and that you will not run afoul of any EEO laws or regulations. And so you generally do that in the end user agreement or in a certification with your background screening company like easyBackgrounds. So let's start with the very first topic, which is the disclosure and authorization. These are the claims we are seeing more than any other claim against employers, and we're seeing them on a class action basis. We're seeing them every day, even after Spokio. We thought that maybe some of these would increase. Basically, they have not, and we'll talk a little bit about why. But what does it require? Well, the Fair Credit Reporting Act is a federal statute. Remember, it's a consumer protection statute. It's 40 years old, and it is meant not to protect employers and not to protect background screening companies, but to protect consumers. So what it requires is that you, as an employer, give a disclosure and tell the applicant, or if it's an employee, the background check will be conducted. That disclosure must be in a standalone document consisting solely of the disclosure. That seems pretty easy. The problem is that the statute then says, and you also must get the written authorization of consumer. Again, it doesn't sound very complicated, except the statute says you must get a standalone separate disclosure, but then it says that the disclosure and the authorization can be in the same form. So on one side, it says you must be a standalone separate document, but then of course can be combined with the authorization, which causes much room for interpretation and confusion, and this is where we see a huge amount of the litigation, because the statute indicates that they can be together. So we're seeing lots of litigation alleging quote-unquote extraneous information, saying that it's more than just the disclosure and an authorization in your disclosure forms as employers, and that it violates the standalone requirement. So what are some of the specifics? Well, the trend really started back in 2012 in the Singleton v. Domino's Pizza case, and then continued in 2013 with the Reardon versus Cloudmate case, where there was a release of liability in the disclosure form, and the allegation was having a release of liability in that form was extraneous information and made the entire disclosure in violation of the Fair Credit Reporting Act. You had a settlement in the Domino's Pizza case. You had then some decisions in 2013, and now many more in 2015. This is what we call the low-hanging fruit. If you learn nothing else from this webinar, you should review your disclosure form on an annual basis, because the law is constantly changing. But you absolutely should review your disclosure form, and you should ensure that specifically it does not have a release of liability in that document, in that form. It does, you are ripe for a challenge or a lawsuit. It doesn't mean it's not defensible, because as you hear a little bit, in order to prevail on a class action, someone's going to have to prove willfulness, reckless disregard for the law. The problem is that now there's so much case law and there's so much media attention that it's going to be a lot easier for people to allege and sometimes prove that you were perhaps reckless in disregard for the law if you keep a release of liability in your disclosure forms. But that's not it. What we're also seeing is any challenge you can think of to a disclosure form we are seeing. So things like, for example, having state law information in your form. Many states have their own state law analogs. California, Minnesota, Oklahoma requires checkbox. California requires additional language. New York, Article 23A, etc. All of these different requirements that the state laws require, in addition to the federal law, you have state law information on your disclosure form. It's being challenged. If you have information that refers to adverse action or other extraneous information, or the fact that you are an equal employment opportunity employer, that anything else that's not just the disclosure and the authorization has been challenged. We've seen electronic signatures on forms challenged, although I think that's a very weak argument. We certainly have seen things like failing to provide a summary of rights as an argument. Now, please understand that under the FCRA, you only have to provide the summary of rights at the same time that you're getting what's called an investigative consumer report. That means it's something that's more than just a garden variety consumer report, criminal background, or a driving record, or an employment or an education. This would be like a reference check. When your background screening company, and easyBackgrounds, is going out and doing specific references, interviews with people, more than just name, rank, and serial number for an employment verification. The other thing is many companies have been separating their disclosure form from their authorization forms. Is a best practice. But if you're going to have that, you need to ensure that you get both of those documents, that you provide both of those documents to the applicant, both the disclosure and the authorization, especially if they're separated. We've got challenges of the allegation that you're going to be getting credit information. You're not actually running credit reports. This we see a lot in New York City, because there's new legislation in New York City with the New York Fair Chance Act. I'm calling that into question. If you are in New York and you don't know about the Discrimination Credit Act and or the New York City Fair Chance Act, you absolutely need to make sure that you do, because it is, we're talking about in the box, but this is, they have added many things that are even required in the disclosure form. And then investigative consumer report language. There's specific investigative consumer report language that is required in many states if you're getting an investigative consumer report. The best practice now, after many years, is to have that be a separate, distinct disclosure other than just your regular disclosure for background checks, because we're seeing more and more of these all the time. Additional authorizations, for example, when someone will say, I authorize the company to provide information to the background screening company, if that is with the disclosure form, we're seeing that called into question. And or if you've got like applicant tracking systems, so different components or different pieces that are all in one. The more separate you can make your disclosure form from everything and anything else, the absolute better. Ways to do this: have a second pass system, so don't have it be anywhere with your application whatsoever at all. Make it be a separate, distinct document after the conditional offer of employment. If you're going to be sending someone the forms in PDF via email, make it a separate PDF document that you provide the individual. Disclosure is separate and apart from the investigative consumer report disclosure, which is separate document than the authorization, which is separate than the California disclosure, for example. If you are going to have an online system where someone goes and enters their own candidate data, either through your background checking provider or through the ATS system, consider in that invite, that email invite, to allow that, having that disclosure form PDF format. They don't have to sign it, they don't have to return it. It's really just for their own information, having them have that as well. This is an area where we see more and more and more challenges. I do think that there's going to be some effect after Spokio. Most of these challenges, and here's the reason why, most of these challenges are brought not by people who did not get jobs. Most of the disclosure claim challenges are brought by people who had the background check run and who then are actually hired and are then claiming that they had this informational injury or some sort of harm. And we'll talk about Spokio. It's going to be crucial for us sending these claims to understand what moral harm can someone have by failing to get a quote-unquote standalone disclosure, especially when they're hired. And that's going to be a real uphill battle for the plaintiff's counsel. The second most common type of lawsuit that we see and that you need to be aware of, because there's more and more challenges to this area, especially in the last couple of years, is the adverse action. So what this means under the law, if you recall, you as an employer have to follow a very rigid, specific, two-step adverse action process if you're ever going to take action in whole or in part based on something on a background report. And it's very detail-oriented, and once you do it a couple times, you get it, and it's not that challenging. But we'll tell you a couple of ways where employers are falling down and where we're seeing these lawsuits made. Understand that before you take adverse action, you must provide the person with a notification that the pre-adverse action, that you might be taking adverse action. So it's a pre-adverse action letter. It has to have a copy of the consumer report. It has to have notice that they can dispute the information in the report. It has to have the CFPB summary of rights, and if there's any applicable states that have summary of rights, you have to have that information as well. If that's not enough, what happened recently in the last 2 to 3 years is that many jurisdictions that passed ban-the-buck laws that we're going to be talking about in a few minutes also add additional requirements. For example, in San Francisco and Seattle, Prince George's County, Maryland, and Montgomery County, Maryland, Chicago, New York City, now recently Austin has been added to this list, and understand that just went into effect as well in Austin, Texas. Now you must have additional requirements in your pre-adverse action order that not only says we're thinking about taking action based on the information in the report, but what specific information you are thinking about taking. Portland, Oregon was actually just passed a couple of days ago. It is not in effect yet, which is what's not on this list, but it is not in effect yet. It goes into effect in 2017, but understand that as well. That's a new one that requires you state their specific reason why you're taking adverse action, pre-adverse action. The New York City Fair Chance Act also specifically requires that you have a specific form and document. In addition, you've got to have different summaries of rights. So different summary of rights, not included here. These are just the ones that have the reason for the action. But New Jersey and Washington and Massachusetts and New York all have specific documents that must go into the pre-adverse action letter. So it's very challenging to keep up with these, and any time that you don't do one of these things, you are potentially ripe for class action. Then, let's say you do the adverse action, you do it correctly, you do all the things you're supposed to do. Then, though, you have to wait a reasonable period of time. So the FTC has defined that a reasonable period of time means 5 business days. That doesn't always mean that, but that's what they have opined. You're going to email the document, or if you are going to hand the document to the person with the Consumer Report, the right to dispute the information if it's inaccurate. With the background checking company, for example, it may be you may have less time, but generally speaking, the rule of thumb is 5 business days. Certain jurisdictions require more than that. San Francisco requires 7 business days. 7 days. So not 7 business days, but 7 days. New York City requires that the person be given 3 business days after receiving your analysis. It's a painstaking analysis under the New York City Fair Chance Act of why the person was not selected. The problem is you don't know when they received the form or received the document. So you have to have sort of a return receipt requested if you were in New York City proper. And it's only New York City, it's not the state. Then and only then, if you followed all these things, waited a reasonable period of time, then you can take adverse action. It needs to be in writing. It needs to have a bunch of different specific bells and whistles that we're not going to go into today, but you should get a template document either from your background screening company and have it legally approved or from your own lawyer. So this sounds relatively easy. So where are we seeing the big areas of concern, and why is it an issue? Well, first of all, I call this the no good deed goes unpunished, which is, and everybody has this, unfortunately, you either set the start date too soon before the background check is done, and so the background check is pending. It's a Friday afternoon, and Monday morning, what's going to happen is the person is supposed to start work on Monday, and Friday afternoon, you see that the person has some sort of very tremendous degree of crime on their background report that is job-related and consistent with business necessity. So what do? Well, one thing that you can do is, one thing you should not do is call the person and say, hey, there's a problem with your background. You can't start on Monday, because that could be deemed to be an adverse action. And so these well-meaning recruiters try to call the person, or they get multiple calls by a person saying, why can't I start, what's taking so long? And they're not trained to know what to say and what not to say. The best thing to say in that situation is your background check is still pending, because it is pending. If you say there's a problem with your background check and you'll be getting something in the mail, what they are going to hear is that they cannot start and that they have lost the job. All of these things become ripe for a lawsuit. So train your recruiters, train your hiring managers that no one should speak to a person about their background check until the pre-adverse has been gone out, waiting 5 business days in the adverse. If you have questions about the background check and you want to talk to somebody and gather more information, the best practice is to give them the pre-adverse action letter so they have it in hand, they can look at the report, and you can ask questions about it. Think about it. If you don't give them that and you ask questions about it, and then you have to send the pre-adverse, then you have to wait the 5 business days, then you have to send the adverse, it lengthens the period of time. Failing to send 2 letters. We have companies that ask all the time, why do we have to send 2 letters? Can we just send 1? The answer is you cannot. It has to be 2 separate and distinct letters, no matter what. There is no exception to that whatsoever. And then auto rejection letters. We see a lot of companies who have applicant tracking systems, and what we find is that applicant tracking systems are wonderful tools, but sometimes what we will see is an applicant tracking system will have the ability to send out thank you but no thank you email at different stages. So for example, if someone doesn't move on, it doesn't meet the minimum qualifications, or if someone not selected for an interview because they're not the most qualified person. For example, those are the types of things where we see an audit letter go out. If a person, though, is being selected, it has a problem because of the background check where you have to send pre-adverse action. You don't then, in turn, want the applicant tracking system to reject the person again. First of all, nobody likes getting 2 rejections. Second of all, the issue is the timing may be off, so that if the pre-ad hasn't done the waiting period and then the adverse, that person may get a rejection letter before that's done, and that's going to be a violation of the law. All of these things are easy to put in place once you can identify them. Another very recent decision is this Manuel versus Wells Fargo decision in Virginia, and the argument is about whether when you go into your background screening company system and or into an applicant tracking system to initiate the pre-adverse action, if the button that you have says fail or ineligible, at least it was called into question in this case of whether or not the decision had already been made. And this is a little bit of a legal fiction because at the time that you're sending out the pre-adverse action letter, or at least a preliminary decision has been made. It can't be a final decision unless and until the person has been given the 5 business days to dispute and to provide you more information, and then the adverse action. So you need to make sure that if you are going into your background screening company system or an ATS system or your own system where it is categorizing the person or classifying the person as a fail or ineligible or do not hire, you want to change that so that you would not get challenged on that. Change the labels in those systems. These are the 2 biggest areas of law that we have seen and the biggest areas of concern for employers in the last couple of years. One other thing that came out end of last year was the workplace investigation exception clarification. This is a section of the Fair Credit Reporting that's very, very narrowly tailored and used only once in a while. It really only refers to companies who are regulated, healthcare, insurance, financial, for example. But basically, it's a section of the FCRA that says you don't have to get a disclosure form if you are investigating suspected misconduct, theft or fraud or harassment, for example, and you have an investigator come in and investigate that. It was written in law specifically so that you don't have to go give notice to the person before you are investigating their either unlawful activity and or their breach of their policy, if you have a policy. The problem is that companies were looking at the FTC basically wrote a blog and said, look, this is for employees only, not applicants. The title of it is Employee Investigations, and it can't be used to say, well, we have a policy against not hiring people with violent crime so that it circumvents the FCRA. So it's a wonderful exception when used in the right circumstances, but it's extremely narrowly tailored. And so if you're going to have a situation where you have your background screening company run something for a workplace investigation, make sure that that's clear to them and clear to you so that you don't for an employment purpose, for example, and then don't have a disclosure form, and then all of a sudden get into that hot water. But instead, it's for a workplace investigation exception. Bandbox, of course, is one of the new areas that we are seeing here. We are seeing this happen more and more across the country. One of the things that is happening with this Bandbox movement, it started with the EEOC criminal history guidance back in 2012, which has been now 4 years old. And basically, the reason that there's this Bandbox, and Bandbox, for those of you who don't know, is really banning the criminal history question or the box of have you been convicted of crime, yes or no, that box. Banning it, removing it from the employment application. The EEOC criminal history guidance in 2012 basically said that if you ask the person that, it's a barrier to employment, and they will self-eliminate, and they will not apply for a job if that question is on the application. Many, many states and local jurisdictions followed suit. So you'll see here out at the state level, we've got Hawaii, Illinois, Massachusetts, Minnesota, New Jersey, Oregon, Rhode Island, and Washington, D.C. At the local level, you've got all of the states that are listed and all counties that are listed. Sometimes it's not a state. Generally, it's not a state. Oftentimes, it is things like these local jurisdictions, and they are making it very, very painful for compliance. So understand that. Different states have different requirements. Different jurisdictions have different requirements. So, for example, in certain jurisdictions, you're not allowed to ask on the application, but you can ask at the time of interview. So, like Illinois is one of those. However, in other jurisdictions, you cannot ask until after the conditional offer. So, for example, Baltimore, Maryland, Columbia, Missouri, New York City, and many others. There's about 6 now that have those specific requirements. If you want a nationwide compliance standard, you should not ask about the criminal history until after conditional offer of employment. If you decide to do so, you do so at your own peril. And we're seeing attorney generals go after these claims. We're now seeing private right of actions on all of these things. And standing up with the ban the box laws are very, very cumbersome. Please note that this list is only private employers. Also should include Austin, Texas on this list as well. But this is for private employers, not public employers. If you are a government or federal contractor, or if you have, if you're a public employer, you have many other states and jurisdictions that you need to deal with. These again are only for private, and they're continuing. We're seeing a huge increase in this. So if you take something else away, consider why are you asking the criminal history question and when are you asking it? The why is oftentimes so that the person can be forthcoming and provide you with information that you need to do the individualized assessment. It's also to show whether someone is going to falsify or not. So there's very good reasons for asking it. The question is when. If you're not looking at the information until you run a background check, why would you ask it on the initial application? And if you're not going to be looking at it until the initial background check, why not do it after conditional offer of employment? It's going to reduce your risk substantially. You can ask a more legally compliant question, and now you're not going to run afoul of the ban the box laws. The other thing that asking it at that time does, which I think is very helpful, is you can have a question that says, have you been convicted of crime? If yes, and again, you have all your state law caveats. Remember, these are the ban the box. Many states like California and Connecticut and Washington, D.C. and Washington State all have their restrictions, how back you can go and what you can ask, for example. Those are different than the ban the box. But let's say you ask the question. If yes, put the sentence and the type of crime and the sentence and the date that happened. Well, you do more than that. You can also say, please tell me, and then you can list those individualized assessment factors that EEOC requires in its EEOC criminal history guidance, which are things like facts and circumstances surrounding the offense, the nature and the gravity of the offense, mitigating rehabilitation factors, where the person worked before and how long they worked. For example, how old was the person at the time of the offense? How old are they now? Was it an aberration, for example, or was this a pattern? How many offenses have they had? All the things you can ask the person to fill out so that when the person who is doing the individualized assessment on your end analyzes, they can look at that. Very important. You do not have to ask criminal history, but if you're going to do it the right way and be aware of ban the law. The other thing, in addition to these plaintiff lawsuits and the numerous amounts that we've seen an increased focus by regulators, both the Consumer Financial Protection Bureau as well as the Federal Trade Commission, have been investigating and doing a sweep of the industry for end users, employers, and consumer reporting agencies, looking at compliance with the Fair Credit Reporting Act. We know of many, many investigations, specifically in the staffing industries, in the gig economy, but they're also in retail space, looking at employers and whether or not they are going to be complying with the FCRA. We're also seeing different. Last year there was a large consent decree. What that means is just a public settlement against a couple of background screening companies, which are going to require some pretty significant changes for background screening companies to make if they follow suit. So what we're seeing here is the legislatures, or the regulators, I should say, legislating. The regulator trying to legislate through these settlement agreements. Big focus on accuracy, big focus on information and additional information background screening companies have to do, but also a very big focus on making sure that employers are doing the right thing. So let's spend the next few minutes talking about the Robbins versus Spoke case and what it is and why it matters and what it means to you and why you should care and understand. So let me give you a little bit of background, which is this is a case where a man named Mr. Robbins found online that a company named Spokeo, who he alleged to be a consumer reporting agency or a background screening company, had information about him online, sort of in the public forum online, that was incorrect. And so he sued Spokeo, alleging that Spokeo failed to follow the reasonable procedures for maximum possible accuracy that's required by all background screening companies or consumer reporting agencies under the statute. Spokeo denied that it's a consumer reporting agency and moved to dismiss the case, and the district court dismissed the case. That case was appealed to the Ninth Circuit Court of Appeals. The Ninth Circuit Court of Appeals said, well, wait a second, and the reason why the case was dismissed was that Mr. Robbins did not allege that he had injured, meaning he did not allege that he had lost employment, he did not allege that he had lost an apartment or lost insurance, all of those permissible purposes under the Fair Credit Reporting Act. So the question for the court was, does a plaintiff need to have an injury, do they need to actually be harmed in order to bring a class action in federal court? That was the question in California. Then it went up to the Ninth Circuit, and the Ninth Circuit Court of Appeals said, no, there's no injury needed. This is for statutory damages. So anyone, you have to have your own injury. Anyone that has been found that somebody violated that can sue for statutory damage. They filed and went up to the Supreme Court. The Solicitor General said, don't take this case. It's not a good case because he alleged that there was already inaccurate information and that was enough of an injury, so they didn't need to take the case. The Supreme Court said, Solicitor General, we're going to go ahead and grant certiorari. And the case was heard, briefs were filed, and the case was heard. I was lucky enough to be there for oral arguments on November 2nd of last year. Everyone thought that the case was going to come down early this year in 2016. And then Justice Scalia passed away. So many, many people thought that what was going to happen was that there was going to be a split. And so what that means is, and think about this from a very high level, what the Supreme Court could have done was everyone thought they would have done three things, one of three things. One, they could have said, yes, Ninth Circuit Court of Appeals, you are correct. There is no injury of fact needed to bring a lawsuit in federal court. And again, this is important, federal court, because it's federal court standing under Article 3 of the Constitution. I know that's a legal concept, but it's important, and for the reasons we'll talk about in just a second. But one, they could have said, no, you don't need to have injury in order to bring a claim under the Federal Fair Credit Reporting Act in federal court, and then we would have seen a huge increase in these lawsuits all throughout federal courts, typically the disclosure claim. Two, they didn't do that. Two, they could have said, no, Next Circuit Court of Appeals, you're wrong. You don't need to show an injury of fact. You have to show, you do need to show an injury of fact, and it has to be specific, concrete harm, particularized, and give examples of what that means, and then they could have applied where he did or not. They didn't do that. Third, could have done a split, because there's 8 justices. There usually are 9 or 4 saying, what, we're not going to make a decision. We're at a stalemate. 4 of us think one, the other 4 think the other, and let's go back down to Ninth Circuit, and we're just not going to make a decision. And so everyone would have gone on their merry way with the stance of the law, which, by the way, the reason why the Supreme Court granted certiorari is because there's a split in the circuits, which means certain areas of the country think one thing and certain areas of the country think another. Those were the 3 things that everyone thought the Supreme Court was going to do. And indeed, the Supreme Court did none of those. So on May 16th, what the Supreme Court did instead, what the Supreme Court said, This is the analysis that the Ninth Circuit Court of Appeals should have done. The Ninth Circuit Court of Appeals should have looked to see if there was particularized injury, concrete harm to the person. The Ninth Circuit, in my opinion, didn't do that, so they remanded the case. However, the good news is, while there's still not a definitive answer, there is excellent language we can all learn from, and I think this is a huge win for employers. Probably the best thing that could happen out of the three things we thought. This fourth probably the best for employers that could have happened. What the opinions say, both dissent and the majority opinion by the Supreme Court, say that in order for a person to bring a lawsuit in federal court, they must show something real and actual, and they must show an injury that is different than the world at large. They were injured in some particularized manner, different from someone else that did not have the alleged violation affect them, and they must also show concrete harm. And while they didn't specify exactly what that means, they said it must be more just a procedural violation. So, for example, a disclosure where someone is hired, but they knew they were getting a background check and they were hired, going to be a large uphill battle for the plaintiff's counsel to prove that they had a particularized injury and that they had a concrete harm. Now, they're alleging and they're making the argument that their injury was that they failed to get a specific piece of paper that they thought they were supposed to get. We think that it remains to be seen if that's going to be an effective argument. The reason why this is helpful for all of those reasons, the reason why this is not a silver bullet and there's no definitive answer here, though, is that the FCRA, unlike many statutes, has what's called concurrent jurisdiction. So if you want to bring a lawsuit under the Credit Reporting Act, you can bring it in federal court, which is what we've been talking about, the standing issue, or you can bring it in state court. And what that means is the state court standing issue of whether or not somebody can bring a claim is very, very different. It's different in every state, and so we're seeing many counsels pull their federal court lawsuits and file in state court. And this is a huge move backwards, because what this means is that there will be nationwide class action cases filed all over the country with varying results, differences in opinions, judges who are excellent judges but that don't know this federal law, with inconsistent results all over the country, because someone in California may do something different than someone in Oklahoma who may do something different than someone in Massachusetts, etc. So very, very big issue. We think that remain to be seen are going to be crucial as to the impact of Tokyo and what happened. Both sides saw this as a win, the plaintiff's counsels and the defense counsels, and so that's really where we are right now with regard to the issue of Spokio. But stay tuned. We're analyzing this all the time and looking at how this is going to affect. So why do you care? And then we're going to get to the final trends and practices and answer some questions. But the reason why you care is because the damages provisions of the Fair Credit Reporting Act are so potentially astronomical in terms of exposure. There's two types of claims under the Fair Credit Reporting Act: negligent noncompliance and willful noncompliance. We hardly ever see negligent noncompliance. The reason is because it's actual damages, and so one person's damages are going to be different than somebody else's versus different than somebody else's. So it's much harder to prove or to get a class certified under the requirements. Under federal court, the requirements are Rule 23A, so it's much harder to get a class certified under that theory. Under willful noncompliance, it's a harder theory because you have to prove willfulness, a reckless disregard for the law. But this damages what's called statutory damages. It's $100 to $1,000 a person. Everyone's damages are the same, arguably for the same statutory violation. You can get actual or statutory, but everybody always alleges statutory so that they can attempt to certify a class action. So if you think about it, looking at the statute of limitations, it's the earlier from 2 years from the person knew or should have known, or 5 years. So what does that mean? In the disclosure case, we argue, and the counsel fight us on this, but we argue that the person knew or should have known at the time they got the disclosure that there was a problem. So 2 years at that time. And if you go back to all the background reports that you've run for the past 2 years, and multiply that by $1,000, probably a large sum of money. Then you add an additional $100,000 to $200,000 for punitive damages, punishment. Then you add an additional $100,000 to $200,000 for the other side's attorney fees, not to mention what you have to pay in attorney fees. Those are the potential damages. And sometimes it goes back 5 years. So for a typical adverse action class, it's how many people have you taken action on in the past 5 years based on the report, and multiply that by 1,000 again with the same punitive damages and attorney fees on that. Huge amounts of money, ridiculous exposure, which is why we're having the webinar today to make sure that you know how to reduce your risk. What are we going to see in the rest of this year? I think that we're going to see issues related to additional regulator commentary. So, for example, I think that the CFP and the FTC are going to specifically talk and perhaps have conversations or no settlements. There was just something that came out for background screening companies. If we can go to the next slide. Additional investigation, I think, in education are going to be helpful. I think now there's going to be more litigation in state court based on Spokio. We've already seen it. We've seen huge amounts of people taking their cases out of federal court and putting them into state court. We're removing them, and they're saying they're standing, and instead of getting dismissed, they're getting back, which are remanded back to state court. We've got a lot of things in the work for workarounds around this, but it remains to be seen. Many, many more plaintiffs' counsel jumping on the bandwagon. This is easy, cut and paste complaints that they can file, and we're seeing a lot more doing so. And new plaintiffs by plaintiffs' counsel. So, you know, the disclosure firm, you know, before 2012, we didn't even have this theory, and then this came into being. So we're going to see even more theories, and with more cases developing and more litigation. So, as a best practice, I would urge you to make sure that you understand what the Fair Credit Reporting Act does. Make sure that you understand the disclosure and the authorization requirements. Make sure that you follow the two-step action process, have your forms reviewed, disclosure forms, and your adverse action processes and forms reviewed at least annually, that you look at your employment application, you ban the box, and think about adding that further in after a conditional offer of employment, and stay abreast on some of the developments that are happening. With that, we've got about 9 minutes left, and so I am going to urge you to, if you have a question, to go ahead and put it into the question box at the side of your screen, and then we will be able to answer those questions as they come in. And I think
we have had a couple questions come through. If you'd like me to go ahead and read those for you. The first one goes back to be in the box. Our application asks, have you ever been convicted of a felony? Is this still appropriate for a government contractor?
Yeah, the answer is it depends. It depends if you are in a state that has a ban the box requirement, either a private employer or that has a federal ban the box requirement. So please understand, you know, President Obama is in the process of trying to push through a ban the box law on a federal level for government contractors. It has not gone through yet. So the recommendation is to take that off of your application and move it further in the hiring process after conditional offer.
Another question we had was, is it a best practice to separate disclosure and authorization, even if the statute says they can be together?
Yes. Are there other questions? The answer to that is yes.
Okay, perfect. The other question is about adverse action, and someone wanted to know what the 2 letters were that were needed.
So there's 2 letters. It's the pre-adverse action letter, and that letter basically says, dear so-and-so, we're considering taking action or in part based on information in your report. Here's a copy of your report. You have the right to dispute the accuracy or completeness of the information in the report. Here's the name of our background screening company, their name, address, telephone, website. You can dispute the information. here's a copy of your background report, here's a copy of any specific rights that you might have in the states that were listed. If you're in one of those states that you have to tell the reason, you may need to say, we're considering taking action based on information report including, and then you fill in the blank, for example, the fact that you had a felony burglary 2 years ago, for example. You have to provide certain information about their rights and specifically providing the information, their summary of rights as in addition of that. Then you wait the 5 business days, and then it's adverse action letter. So-and-so, thank you so much, but we are unable to offer you employment at the time, or we need to reject your offer of employment. You previously received a pre-adverse action with a copy of your report. You still have the right to get an additional copy of the report by contacting the background screening company. There's very specific requirements. You should get a template from either your background screening provider and have that legally viewed on your own, or you should have it get from your own counsel.
Just a couple more. Can you consider accurate or deferred charges when evaluating a background?
So the answer is, presumably we're talking about pending charges here, and the issue with regard to pending charges is these are the hardest things to do, and many states have prohibitions on whether or not you're allowed to deal with non-convictions versus pending charges. So if someone was convicted, for example, if someone was arrested, for example, 2 weeks ago and that's currently pending, you have to decide where you are in the state, what state restriction you are to determine if you can take action on that. If someone has had a non-conviction, I mean they were arrested and the case was dismissed, you should not be taking that into consideration, or if it was expunged, for example. It's really case-by-case specific situation of where the person is, where they're applying.
I see one last question. The offer letter of employment disclosing the need of a background check count.
Yeah, so I'm assuming this means as a disclosure, and the answer is no. You must have a separate, distinct disclosure. It cannot be part of the application. It cannot be in the last paragraph of the application. It cannot be in the offer. It has to be a separate and distinct form with very specific requirements.
One last question, actually. What dates can you do credit reports?
So there are currently 10 states and 2 jurisdictions that have prohibitions on use of credit. So the 2 jurisdictions are Chicago and New York, and then 10 other states that have restrictions on when you run credit. There's no federal restriction on when you can run credit. So most of those states, like for example Illinois is one of them, you need to make sure that you fall into an exception. And if you do not fall into an exception, then you cannot run credit. The EEOC abhors the use of credit. I believe it has, like criminal history, a disparate impact on people. We would strongly recommend that you reduce the number of positions for which you actually run credit checks.
I think that's all the questions that we have today. So thank you everyone for asking.
All right, well, great.
Yep. Closing, yeah.
Thanks everyone for attending. We certainly appreciate it. On behalf of Seyfarth Shaw and on behalf of easyBackgrounds, we certainly appreciate your attendance. If you do have additional questions, feel free to reach out to easyBackgrounds and they can get connected with the right person. Ryan, any parting words?
No, thank everybody for their time and enjoy the rest of your day. Take care, folks.
Thanks, everyone.